So hi, everybody. Welcome to our webinar today on the new and improved, we hope, power of attorney law in New York State. I'm using some PowerPoint today because I think it's important when we're talking about a new law to stay focused and clear on exactly what we're talking about. So let's start with what is a power of attorney. A power of attorney. So it's a document, right? At its very core, it's a document. It says who can make some decisions on your behalf, and what decisions that person can make depends on how the document is written. So if a power is granted in the document, if we say that someone can make a certain decision on our behalf, then the agent has that power. If the power is not listed, you can't do it. I often tell clients when we're sitting with them, this is a duplication of your powers. So this isn't saying that now, someone can do banking transactions for you, for example, but you can't do them for yourself. You can do them for yourself. It's just that there's another person who can step in your shoes and also do them for you. It does not require your incapacity. So there used to be something used often called a springing power of attorney that would spring into effect if a doctor deemed you incapacitated. We don't like to use those so much anymore. And as we go through the requirements of signing a power of attorney, you might see part of the thing, something that we do in order to make sure that someone doesn't have power before you want them to. But we get very nervous involving physicians in somebody's capacity because a physician may not want to go on record as saying somebody doesn't have the capacity to handle their financial affairs because they might not have that information. But it might be true that somebody needs help. And sometimes we need the help of a power of attorney and we're not incapacitated. We just need that assistance. And so it does not require incapacity. The document can allow for compensation of that agent, although we often don't compensate an agent that's a family member, but you could, and there's other cases where it makes sense to compensate a non-family member or someone that you're hiring to be your power of attorney. And I want to go through some definitions. So the principle. So if I'm signing a power of attorney, naming someone else that can make decisions and handle affairs for me, I'm the principal and that other individual is called my agent. So I'm signing the document and I'm naming an agent to act on my behalf or multiple agents to act on my behalf. There's also room in the document for what we call a monitor. Now, standardly, we don't use the monitor function in every case, although there are certain circumstances where someone is acting as a power of attorney and somebody wants there to be a second set of eyes on things, and so they may name a monitor. A lot of times, we will just name two agents to act, and they can either act together or they can act separately. But if they have the ability to both act, they have the ability to check up on one another. And revocation, you can revoke power of attorney. So the main times that these are revoked is if you expressly revoke it, either by a new power of attorney that says this power of attorney revokes all prior, and it has to actually say it for it to be done. Or it can be revoked if you sign a document and say, I'm revoking the power of attorney dated February 16th, 2021, naming X person as my agent. And then, according to the statute, you have to send a copy of the revoking document to the individual who was named to put them on notice that they should no longer act on your behalf, and also to any institution that you may have given the power of attorney to. So if I gave my bank, where I have my checking account, a copy of my power of attorney document because I want this person to be able to act on that checking account, well, if I no longer want that person to act, I need to let the bank know so that they can operate accordingly. So the history of the power of attorney. This is not meant to be a law school class, but I think it's very important that we discuss the history of the power of attorney document because most of you out there, or some of you out there, may have documents from the past. And so it's important for you to know what is going on with those documents. And we're going to get into in a little bit what's going to happen in the future with documents that you may have signed before. So in New York power of attorney law, there's after 2009 and there's before 2009. Any document before 2009 was likely 1 or 2 pages. It just gave those standard list of powers, A through O, with the catch-all at letter P. And it is understood, or was understood at the time, that your agent was taking over all those powers. And then it became very clear, and the law changed. It became clear that we had to deal with the fact that this document was handling the affairs of somebody who was no longer had capacity. I should have said before, let me go back, in my definitions, the word durable. Everybody always asks what a durable power of attorney is and do they have one? Well, in New York, it is now deemed that all powers of attorney are durable unless you say they are not. Durable means that it's in effect now when I sign it, but it's also in effect if I should become incapacitated. So the duration, the durable, is now and in incapacity that it's in effect. I will say the difference is at your death, it's again revoked. So similar to those other times that I said it was revoked, it's also revoked at death. So if somebody dies and 2 days later you want to go to the bank and handle the affairs in their bank account, that power of attorney doesn't work anymore. And then it becomes an estate issue that we would deal with. So go back to 2009, the law changed and there was something added at the time called a major statutory gifts rider. Then in 2010, they changed it to be called a statutory gifts rider, but it was basically the same document. And this talked about any transfer of assets out of a person's name, not for consideration. So what does that mean? If somebody has a power of attorney document after 2009, just the power of attorney, that allows someone to pay bills, to do certain transactions, depending on the modifications that were put into it. And there was a whole section added where you could modify the document and add in powers to apply for Medicaid, to pay staff, all these different things. This is the payment for goods and services and acting on someone's behalf. If you wanted to give a gift, and that's paying somebody $1,000 for their birthday or for their wedding, it's making a charitable donation, it's transferring assets to a trust on behalf of that individual that you're acting on their behalf of. All of these things now required this additional document, which was called the statutory gifts rider. And this statutory gifts rider was attached at the back of the document. It had to be signed at the same time that the power of attorney was signed. So you couldn't sign this power of attorney and then later sign a gifts rider. The power of attorney document required a notary, whereas the gifts rider required a notary and 2 witnesses, one of which could be the notary, but it had that extra witness requirement. And again, this was for any transfer of assets that was not payment for goods and services. And so a lot of people were confused that when you had a power of attorney, that didn't just give this all-encompassing power anymore like the prior law did. In 2010, when those minor changes were made, it changed the major statutory gifts rider to being a statutory gifts rider and made some other small changes. The other big change in this 09-010 time was that the new document included the signature of the agent. So it wasn't just enough that I was the principal and I sign a document and have it notarized giving the power to someone anymore, like I could do in 2008. Now that individual that I was naming as my agent has to sign a document accepting the job as power of attorney and accepting that they're going to act in my best interest. And so you see that the execution of the document got to be a lot more complicated. So now I have to sign it, my agent has to sign it, we both have to have it notarized. And if I'm doing the statutory gifts rider, I need another witness in the room as well. And so it got a little more complicated. And the part with the statutory gifts rider actually said that if you're thinking about signing a statutory gifts rider, you should have the advice of an attorney, because now you're giving a very large power to the agent that you're naming. You're allowing them to transfer assets out of your name, and you just have to trust that they're doing it in your best interest. Now, there are remedies in the law for if they do something improper and someone could come after them, but someone would have to find the problem and identify it and bring the lawsuit. And so now it was making it a little harder for agents to just do whatever they wanted. And so we were holding people more accountable. But one of the big problems that we had with this document was that, let's say somebody had a 2009 form from the state, but they signed it after the 2010 change in the law. Well, now that wasn't a valid document because it wasn't valid when it was signed because it was the wrong format. And these minor changes created very big problems because often we weren't finding out there even was a problem until well after the time that we had to, that the person didn't have capacity anymore. So then 2020 comes, and in December of 2020, this new law was signed. So the Assembly and the Senate of New York State signed and passed the bill. And then on December 15th, the governor signed it into the law. Now, this has been something that's been in the works since 2015. The New York State Bar Association put together a task force of the Banking Committee and the Trust and Estates Committee and the Elder Law section, and we all came together and put together a new proposed law. And proponents from the Bar Association have been working on this since to get it passed. We're going to talk today about the law that was changed and maybe some additional changes that might happen. So what's new, right? What changed? So dates, where dates have to be put in, the wording, this was changed, standard formatting. But again, the old law said that it had to exactly comply. So if you had a few words off, again, because you were using the 2009 document in 2010, and the gist of it was the same, but the words were different, you didn't have a valid document because you didn't have this exact wording. Substantial compliance now under the new law says that you can have a few words off, or you can have something that's a little bit out of place. And if that's the case, as long as the meaning and the intent are clear, and it's not a variation on the form that makes it so that it's not clear what the principal was trying to do in conferring these powers, then the document's going to be okay. And that's a big deal because these small mistakes, these small errors of drafting aren't going to ruin the entire document. We've gotten rid of the statutory gifts rider. It is eliminated. What they've done is they've taken the concept and the powers that were granted for these gifts to be given, these uncompensated transfers to be made, and they've moved it into the modifications section of the document. So instead of having two separate documents that have to be signed at the same time with different and differing ways and witness signatures, et cetera, we now just have one document that has to be signed by the principal and then also signed by the agent. How the signing happens has changed. So now it's that the execution of the document, the signing of the document, has to be done in front of a notary, and it can't be and there needs to also be, there's going to have to be a witness as well. So a notary and a witness, and it can also allow for someone to sign on behalf of a principal who can't physically sign. So this is a big deal for our community of those with physical disabilities. There are some people who have the mental capacity to say, yes, I want X person to be my agent. I want them to serve on my behalf. I trust them. I know they're going to do the right thing, but they can't physically affix their name to a document because they don't have the ability to sign their name. Well, now, as long as a person has mental capacity and can direct another person to sign on their behalf, they can do so. And that is a huge deal for the disabilities, the physical disabilities community. And that person is going to have to be in the room with them. They can't just be signing at an office when the principal's somewhere else completely. They're going to have to be in the same room. The witnesses are going to have to see that the principal is saying that this is what they want and they're expressing that. And then the person can sign on their behalf. The person signing on behalf of the principal can't be the agent that's being named, and it can't be anyone who's named as someone who can receive gifts under the document. The other thing that's gone up is it used to be that you could only give up gifts or maintenance gifting to family members of up to $500 without the statutory gifts rider. Now that number has been raised to $5,000, and if you want to give gifts or transfer assets above $5,000, then you're going to need those powers put into the modifications section. You also want to remember that the document is still under the concept of if the power is not listed in the document, you don't have it. You're specifically under this new law going to want to look at retirement transactions. If you have an IRA, a retirement account, and the agent wants to change who the beneficiaries are under that account, it's not going to be enough if the document says that that person can do transactions under retirement plans. It's actually going to have to say that that individual can change beneficiaries under retirement plans. This is going to go the same for adding a joint account holder. If the principal wants the agent to be able to add a joint account holder to an account, then the document's actually going to have to say that that specific power to add a joint account holder is granted, and then the agent can have that right. The other change is that because of this substantial compliance, we can delete things that don't apply. So for example, I have clients who are not compensating their agents, and they want to delete the section that says compensation to agents. But under the current law, I can't do that, because if I do that, I'm altering the form. I have to comply with exact wording, and now I'm making an invalid document. Under the new law, I can actually delete that section and write intentionally omitted. It makes the form shorter, it's less confusing because it doesn't include things that don't apply, and then we can go on and sign the document. And so there's a lot more flexibility with this new document that we're hoping is going to make it easier and more user-friendly. So will banks stop giving you a hard time? So what am I talking about here? I have a lot of clients who come to us and they say, I brought the power of attorney for my mom to the bank, and I said I want to go on the account, and they told me that the power of attorney was too old. That it was too old, it wasn't valid anymore. Now, too old, there's no law that says that that exists. As long as it's a valid power of attorney and it doesn't have a period of time written into it by which it expires, by statute, it does not expire. And so what was happening was banks were rejecting these powers of attorney, and people were left without any recourse. And so the goal here is that we've put into this law, the legislature and the governor has put into this law, that we have a way to deal with the banks now. And there's a set process. And so we can do an opinion letter by counsel. So the lawyer can actually say what the person's mental status was, and the opinion that under the law at the time that the document was signed, that it was a valid document, and that to the best of the attorney's knowledge, and certainly to the best of the agent's knowledge, that this has not been revoked, and that could be done. And as a bar association, they're working on, the State Bar Association is working on some sample letters so counsel can understand what they have to put into these letters. We've also put what we like to say is a little teeth in the law. So these institutions can actually be liable for damages, including reasonable attorney's fees and costs, if the bank was unreasonable. Now, if the bank has a reasonable purpose for rejecting a document, then that's fine. And they have the right to do that, because we do want to make sure that with elder abuse or abuse of other vulnerable persons, that they are taken care of. But we also don't want to create unnecessary harm to those who have a valid power of attorney and someone acting under good faith who's trying to assist them. And so in order to fight this and try and keep it as only reasonable purposes for rejecting a document, we put this teeth in where now when a proceeding is brought, attorney's fees and costs can be assigned. These protections can apply to older powers of attorney, again, as long as they were signed properly at the time under the law that they were signed. When somebody gives a power of attorney over to a bank, the bank has 10 days to either honor the power of attorney and say, yes, this is a good document, or to reject it. And there's certain requirements for who they give that information to, the rejection or the honoring, the approval. Then there's time for the person to respond to the bank. There's actually no time limit put on that. And then once I respond and say, no, you should accept it because of these reasons, then, or with the opinion of counsel, then the bank has 7 days to do their final review and either honor it or reject it. And so the idea is that these things won't go on forever and that we can control the time. So this law that we have, is this the final document? Have they suggested that this is what we're stuck with? Well, no, we are expecting an amendment to come out of Albany. There was some, the way laws work in our state is that a law is proposed. There's a sponsor in the both houses, in the Senate and the Assembly, and it passes through. And if passed, then it goes to the governor for signature. And when this specific law was waiting to be signed by the governor, there was some groups that came up and said that they were concerned about abuse on the vulnerable persons and elder abuse, and they wanted to make sure that there were certain extra provisions put in. And so that two-witness requirement that I was talking about is going to be put in. That's actually not in the law that was just signed in December, but that's likely to be put in through an amendment. And when the governor signed the law, he actually issued a memo stating as such. So we strongly believe that's going to come down, and we're waiting for that to happen. When does this become effective? So we have a new law. It was signed, as I said, on December 15th of 2020. It's not going to go into effect until June 13th of 2021, 180 days after it was signed. So it's important to know that we're telling you about this now so that you know it's coming up. You should not be signing a new power of attorney until after June 13th of 2021. The new form and the new law are not yet in effect. And so if you sign a document now under a law that is not in effect yet, you're not going to have a document that's going to be valid. So you want to wait until after the law has gone into effect. We also are waiting for these amendments to come through, and you want to make sure that whatever you are signing is the most up to date if you are going to update, or if you've never signed a power of attorney, re-sign your documents. So the big question that we get from people is my old document still valid? So we have people in our offices today or on Zoom because of COVID. We can sign documents via Zoom and notarize them and witness them, who've been signing documents over the past few months or certainly over the past few years. And now they're worried. Now a new law is coming into place. Do I have to sign a new one, or is my old document valid? Your old document is valid as long as it was signed at the time, it was signed validly under the laws at the time of the signature. So now if you have a document that you signed in 2019, but it didn't comply with the law that was in place at that time, well, then it's not going to be valid. But assuming it was valid at the time it was signed, you have a valid document. That being said, I always tell people that you should be having your estate planning documents reviewed every 5 years, or if there's a big change. Now, certainly a big change in the law is one change like this and like other changes we've discussed on these webinars. Also a change in your family structure. Maybe your children have become adults and you feel comfortable naming them as agents. Maybe somebody you had named as an agent or as a successor has passed away or otherwise become unable to act. So you should be reviewing those documents to make sure they're still okay. I'm not saying that everybody should run out on June 14th of 2021 and sign a new power of attorney. That's not going to be necessary. However, we will see, I'm sure, as we saw with the other changes in the law that happened, that over time, the banking institutions and other institutions that you want to honor this document become comfortable with the form. And so sometimes it's just easier to get an updated document because you're dealing with an institution that's used to that document. I don't think that that's necessary at this point, and I don't think we're there yet, but down the line, that might be necessary. Certainly when people come to me now or came to me over the past few years with a document that was signed before that major 2009 law change, I tell them you should have a new document, not only because I want to make sure that they have an easy to use document that the banking institutions and other institutions recognize, but also because that change in the law added in the modification section, added in the gifts rider. And so we had people coming in with '06, '07 documents that they signed at that time, but they didn't have any rights to transfer assets to trust or do any type of planning that we often do when working with clients, especially in the Medicaid asset protection context. And so we were saying, well, does the principal still have mental capacity? Because if they still have mental capacity, we want an updated document that, again, is going to be easier to use, and that is going to be a document that that allows these things to be done. Now, the change in law we have now, it's those modifications and those rights to gift are in the existing law as well as the soon to be the new law. And so that's less of a concern. But yes, your documents are still valid. So does anyone have any questions? I see some here.
I see we've got a few questions up. The first one being, what is the difference between a will and a power of attorney?
Good question. So a will is a document that states your wishes for how your assets should be transferred at your death, so how they should be dealt with. So a last will and testament is your statement of your wishes. It says who will be named as your executor to handle your assets after your death. If you own a home, perhaps it's, I want my home or my apartment sold and the assets distributed to these 3 individuals. It has your wishes. And the power of attorney document is while you're alive. So like in the example I gave before, if you are the agent for someone on power of attorney, and you're on their bank accounts and they have a checking account and they're the only name on it and you're on as power of attorney, and then they die, you no longer have the right to use that power of attorney document and access the funds. It is now up to the named executor to get appointed by the court as executor and then go and collect those funds. And so there's a time period in which it cuts off from power of attorney and hands over to the executor who is nominated under the will, but appointed through the probate process.
Thank you, Britt. Next question. I signed a power of attorney in 2019 and was witnessed. My agent has not yet signed the document. Is this still valid or should I do a new one?
So your agent, that's a good question. And I meant to say this before, so thank you for bringing this up. There is no time limit in the statute by which your agent has to sign the document. So you sign the document and have it notarized under the old law, and this person said they signed it in 2019. So under that law, they then at the same time had to sign the statutory gifts rider and have it witnessed and notarized. But then a lot of people wait to give the document to their agent for signature because they don't have a springing power of attorney that requires incapacity, but they might not be ready for their agent to act on their behalf or to have access to their accounts, et cetera. And so a lot of people would sign it and hold on to it and just let the agent know that if it came time for them to act, where the document was so they could go get it and sign it at that time. So you don't have to re-sign your document just because your agent didn't sign it. You don't need a new one.
Thank you, Britt. Next question. My mother, who lived in New Jersey at the time, had the power of attorney done in 2018 by a New Jersey elder law attorney. She now lives in a memory care unit in New York. Is her power of attorney still okay?
So maybe. I would say that, first of all, if she doesn't have mental capacity to sign a new document, there might not be much you can do. But whether or not a power of attorney that somebody signed is enough to handle their affairs depends on what their affairs are. And so I would say it makes sense to have an attorney in New York review that document. And if your mom still does have capacity, perhaps sign a new one while she has capacity if there are powers that are not listed in that New Jersey document that may be needed down the line.
Thank you, Britt. I need to replace the person who holds my power of attorney upon my death because this person is no longer capable of handling the power of attorney after my passing. Should I wait until after June 14th or do it now?
So good question. I want to just start by saying, so the power of, you're referring to a power of attorney upon your death. So remember, the power of attorney does not last after death. So until you die, it's an agent under a power of attorney who would act on your behalf. And then after your death, it's potentially an executor or a trustee, depending on how your estate is set up, who would be handling things. But if you are a person who needs a power of attorney because you want to change things, I wouldn't recommend waiting the 4 months because delays happen. And if you have someone who's named on your power of attorney, you don't want them to act and you don't trust them and you don't think they can handle it, what happens if between now and June something unexpected should happen to you and you need them to act and they're not able to? So I would suggest that if you have documents that you're not happy with who's named on them, that you change them and don't wait for the new law, just to make sure that your wishes are followed.
Thank you, Britt. Next question. Do family members have access to the contents of my power of attorney if agent is a bank or person unknown to other family members? Can it be registered someplace like a healthcare proxy living will?
So it can't be registered, and I think that something was floating around for a while about registering powers of attorney, but that has never actually happened. So you can have a power of attorney, and it's private until you give it over to somebody because you want them to accept it. You want them to deal with the agent instead of dealing with you. There's nowhere to put it on file. Family members only have access to it to the extent that you give it to them. So a bank is unlikely to serve as your power of attorney, but let's say you want your accountant to be your power of attorney and your loved one calls the bank and says, I want to access mom's bank account. And the bank says, well, you're not named as the power of attorney. And your family member says, well, who is? The bank's proper response would be, I can't share any information with you. You're not the power of attorney. And so they can't just get the information just based on being a family.
Thank you. There's no additional questions. I don't see anything else here. Just like we said in the beginning of the webinar, that this will be recorded and uploaded on our website for future reference. And I think that's it, unless you have anything else, Britt.
Yeah, I see somebody has their hand raised, so if that person wants to write a question in the Q&A at the bottom, I can certainly address it, and I can give it a minute so they have a little time to type that out. But I think in closing, I would just say, we're keeping you informed of this new change in the law, and it's not going to be in effect for a few months, and I don't think that it should stall the planning that you're doing, as I said, or make it so you don't sign new documents. But you want to be aware that there's a change in the law, because if you come to July, say, and you go to sign a power of attorney and somebody gives you a document that has two separate documents, a power of attorney and a statutory gifts rider, it should trigger in your head to say, wait a minute, back in February, I listened to that webinar and they said there's not two separate documents anymore. It's all included in the one document. And there aren't two places for me to sign and have it notarized. And so you just want to have this information so that down the line, you can be triggered to, wait a second, I should be talking to a lawyer about this. Something about this seems to fly in the face of what I learned on that webinar. And that's really the most important thing to remember. We'll continue to give you updated information about this, and certainly we'll be writing articles about it and putting them on our website.
Thank you, Britt. There is one last question, is where and how do I register for a healthcare proxy and living will?
So that's a good question. I actually don't have that answer for you, but if you email us, I can get it for you. A lot of people with a healthcare proxy and a living will, I believe there is a state registry, but most people will have it on file with their hospital system. So say if you're a person who sees a Northwell doctor, you'll have it on file with the Northwell system so that all the doctors in that system know that that is what it is. Or if the closest hospital to you, if you're on Long Island, say, is a Northwell or a Stony Brook, or if you're in the city, it's Mount Sinai, NYU, whatever it may be, you want to make sure that that's where it's on file so that if you are brought to that facility, they know who to call. I would also say it's very important that your important documents like this be put on the back of your door or on your refrigerator if you're concerned, getting into the healthcare proxy and the living will that say the EMTs are going to come and take you to the hospital. They're trained to look in those two places. And if you have documents, they will bring them to the facility and have handed over to the staff at the hospital who will be able to call you, the person named on your healthcare proxy.
Thank you. If there is no will, would a power of attorney still be in effect?
So yes, they have nothing to do with each other. So if somebody doesn't have a will, but they have a power of attorney, then all while they're alive, the power of attorney is in effect and that agent can act on their behalf. But then upon their death, the power of attorney is revoked, doesn't exist anymore. And then how the estate is handled is going to depend on how the assets are structured and how the estate has been structured. Or if nothing's been done, there's a court proceeding for that too. But one, you can certainly have a power of attorney and not have a will. We don't recommend it, but it certainly happens.
Take care, everyone.
Thank you. Have a good day.